Welcome to our Curious Amalgam, the weekly podcast brought to you by the Antitrust Law section of the American Bar Association. Our Curious Amalgam explores the fascinating and increasingly overlapping world of competition, consumer protection, data protection, and privacy law. Each week, we bring you leading global experts on the most compelling issues of the day. Enjoy the show.
In April 2022, the ABA Antitrust section convened its 70th annual spring meeting, bringing together over 2,500 practitioners from the U.S. and abroad. It's a unique opportunity for our Curious Amalgam to interview several of the international enforcers live, including representatives from the European Commission and the UK Competition and Markets Authority. Here's what they had to say.
Hi, this is Anant Raut, and I am here with Director General Olivier Guersent of the European Commission. Welcome to the podcast.
Thank you.
Director General Guersent, what is your top priority for the next year?
Well, you might know that we have just concluded the political agreement on the Digital Market Act 2 weeks ago. So I guess the political priority for the next year will be to get it softly landed on the ground. There's a lot to do. We need to go through designing all the implementing rules. We need to designate the platforms, the core services. We need to go along with them in order to see wherever implementation proves complicated, what's the best way to implement it together with the platforms. So it's a bit more than a year of real hard work before the DMA is fully operational, and that is going to be probably our biggest priority.
And do you have a timeline for what the next steps on that are going to be?
Yes. So, our system is complicated. So what we have is an agreement in principle between our two chambers, which are the Council of Ministers and the European Parliament. Now the final text needs to be finalized, which is what we're currently busy doing. Then it will be voted formally by the two assemblies, and that is going to take place in July, most probably. After this, we'll need to get a bit more than 20 different languages, all of which should mean exactly the same thing from a legal standpoint. So we have what we call the lawyer linguist revision, which is frankly a pain in the neck because it's difficult sometimes to square that circle. And once all this is done, it's published in the official journal of the European Union, which we expect will be the case in October, probably. And then the regulation kickstarts 20 working days after that publication. So 20 working days after that publication will start the first 6-month delay for designing, implementing rules. So that's basically us being busy, but we will probably need to consult the industry, the member states, etc. A number of obligations need to be precise, procedures, this type of things. After this first 6-month period, we'll open a second 6-month period, which is called designation period. And that is when we will designate gatekeepers. For some of them, it will be easy because we have a set of thresholds. If you're in threshold, you're designated. But of course, you always have a possibility to say, well, although I'm in threshold, I don't think it should be designated. So, and they can file rebuttal memos, which we have to answer to and make a final determination. And we have also the possibility to designate so-called qualitatively. So you do not meet the thresholds or you do not meet all of them. But still, we believe you should be designated as a gatekeeper. And in which case, of course, logically so, it is a more demanding process. So that's for the second 6 months. And then you have a third 6 months. Implementing measures are done. Platforms are designated. And then they have a maximum period of 6 months to be fully compliant. So to adapt whatever they have to adapt in order to be compliant. And so after these 18 months, if they're non-compliant, then we'll start real enforcement.
Well, I know it's been an enormous undertaking over the last few years, and I know that a number of jurisdictions have also been following this to see your approach in these matters? And this leads into the next question, which is, what do you think is the most important trend that you're seeing in competition law enforcement that's going to develop over the near to midterm?
Well, it's difficult, and maybe it's different in the EU and in the US. One trend is certainly that we see a degree of convergence between the EU and the US that I haven't seen for a very long time. That's in particular true in digital. Of course, digital is immensely important. So that, I think, will be important. I think as we shall see whether the US adopt legislation that have the same objective as our Digital Market Act. I understand the jury is still out, but it's not unlikely. Whether they do it or not, I think this type of outright prohibition for a number of behavior will generate, with the big platform, a number of questions about how can we reach the same effect without infringing the DMA, which I assume will launch a new era of creativity in implementation of Article 102 of the treaty, so dominant standards, the abuse of dominant standards in the EU, but also around the world. And also because, of course, a large amount of the practices we see in the digital sector are, if you lift the veil of technology, at the end of the day, it's pretty much the same as what you could have seen 30 years ago. I mean, bundling, they did not invent it, tying either, leveraging in all the ways that was happening before. It is simply faster, more powerful in the digital world, so and more complicated because you have huge amounts of data to crack in order to understand how it works. But in essence, this is the good same old stuff. While I think with data, you have the potential to see practices we've never seen before. And therefore we will have to actually to invent the new theories of harm that go together if we think it's harmful. The judge will be confronted for the first time to this thing. So it will require qualitatively an extra effort on our side. And I'm pretty much sure that this is the way things will develop.
And on top of that, you also have the Digital Services Act that's expected to come into effect.
Yeah. Well, this one is fortunately is not square in my portfolio because the Digital Market Act is competition law inspired. It's not competition law because it's ex ante, but I mean it's based on 25 years of enforcement of competition law in digital. Well, and it's asymmetric, so it's only about these large platforms that enjoy kind of super dominance in markets that command access to a number of other markets. While the DSA is symmetric, it's about the things we don't want to see in internet in Europe. Clear example, I don't know, child pornography. You don't want to prohibit it only for Google. You want to prohibit it across the line. So that's the difference, and therefore, because it is much more like any normal digital regulation, this one is really very much within the scope of my colleague dealing with these issues. There are border issues, of course, however, because for some issues like targeted advertising, the gatekeepers face extra obligations because of their very substantial market power. So you have a rule for everybody and you have an extra layer of rules for them. And of course, we'll need going forward to make sure that the two rules and their implementations operate smoothly one with each other.
What tips do you have for practitioners who want to advocate effectively in front of DG Comp?
Well, I guess come early, be genuine. I mean, try. I mean, if you come, you have to come to solve the problem. So hiding the embarrassing facts, knowing that mostly we finally discover them, is normally not a super smart strategy. So commonly be genuine, expose your problem, don't hide major facts that are relevant to the case. And that's the best way to solve your problem going forward. That's very, very true in mergers, for example. I mean, coming late, trying to rush the case, putting everybody under pressure, that's very rarely the best way to have a nice outcome. So whenever possible, I mean, come early, do things properly, be genuine, be honest. Don't lie. Seems obvious, but you may fool me once, of course. But that's a repeated game. You will meet me again. And next time, I will simply not listen to what you say because I cannot trust you. So trust with the authorities is something that is long to establish and easy to destroy. So it's the main capital of lawyers. The ability to explain me things in informal conversation that they would never put on paper, but help me understand better what is the problem. Of course, we can have an agreement. I will forget this as soon as they leave the room. You need to have a high level of trust for this type of things. That takes years to establish. And if you step a bit outside of the line once, it's gone forever.
So don't try to game the commission.
Well, you can try to, but in my experience, either it doesn't work and it's bad, or it works and it's bad later.
Yeah.
But either way, it's never good in the long run.
One final question. So here on the Curious Amalgam podcast, we try to give listeners not just insight into competition and consumer protection law, but also some insights into competition and consumer protection luminaries such as yourself. So one question that we have for you is, when you're not working, what is your favorite pastime?
Oh, well, many things. Doing nothing is something I love because it's such a scarce good that I cherish it. No, I used to play rugby. I love rugby. So whenever I have time and I have the opportunity, I'm going to the stadium looking for a good World Cup or Six Nation tournament game. Is something I love. I actually had bought tickets for the World Cup in Japan, France against England. So that we call that the crunch in Europe. So that would have been the highlight of, at least for me, of the World Cup, and it happened on the day of the hurricane. So the game was cancelled. I was locked in my hotel, and I was locked in Japan for the next 4 days because, of course, the time that they resume international flight, etc. After that, everybody wanted to have a seat in the first airplanes to take off. So a pretty big disaster. But this is what I like to do. Rugby, I would say, would be my favorite.
That's great. Well, Director General Guersent, thank you so much for joining us on the podcast.
You're welcome.
My name is Anora Wang. Today, I have the pleasure to speak with Martin Coleman of the United Kingdom's Competition and Markets Authority, or commonly known as the CMA. As a panel chair, inquiry chair, and non-executive director, Martin is responsible for setting the CMA's strategic direction and policy framework, developing priorities, monitoring performance, and making decisions on phase 2 mergers and market investigation references. Martin also currently serves as deputy chair of the Office for Students, which is the regulator for higher education in England. Before joining the CMA and also serving the Office for Students, Martin practiced law in the private bar, leading the law firm Norton Rose Fulbright's global competition practice. So we're very happy to have you. Without further ado, Martin, welcome to the program.
Hi, Anora. Glad to be here.
pleasure is all ours. I just have very few questions, but they're all very high level, very comprehensive. So first of all, what is your top priority for the next year?
Well, we've got a lot of important things to do, but I think a really key one is as we come out of the pandemic, as we face new challenges caused by the war, cost of living crises that as a result of these factors, protecting consumers from unfair practices by businesses as the economy changes, as the world changes, as technology changes, is an absolutely key objective for us.
That sounds like a whole list of things to do. So do you have any observations, I guess, or of the most important trend that you see in competition law enforcement that would develop over the near to midterm? I guess we mentioned the pandemic and the war, but like more specifically with the UK, anything top of your list?
Well, what is really important for us is targeted enforcement. Mm-hmm. All competition agencies have limited resources. Mm-hmm. They have a lot of demands. So when you take action, mm-hmm. it's important that it is focused and it is targeted. Mm-hmm. So it needs to be targeted in terms of the kinds of instruments we use, in our choice of cases, in the issues that we're looking at, and in the remedies that we're imposing if we decide to impose any. Mm-hmm. So let me give an example. One of the issues that is important for us this year is sustainability and net zero. Mm-hmm. So we have looked at that in a targeted way. On using our antitrust, our competition powers, we have taken action in relation to long-term exclusive agreements mm-hmm. between electric vehicle charging companies and motorway service centres so that we can hopefully widen the choice for consumers. Using our consumer powers, we've been very concerned about greenwashing, false claims mm-hmm. about environmental sustainability. Mm-hmm. So a targeted approach.
I think that's one of the areas, you may say many, where UK is ahead of some other jurisdictions, maybe including the US on sustainability front. So do you think very much is the agency driving that development and also the business is following along, or the other way around?
Well, look, I think the two can go together. Mm-hmm. So one of the concerns, for example, on sustainability that we have heard is that the competition rules make it more difficult mm-hmm. for businesses to do things on sustainability than otherwise. Now, we've not seen much evidence of that, but mm-hmm. we have thought it important to give guidance to businesses about what they can and can't do mm-hmm. in terms of cooperation on environmental issues. And we've also given advice to our government about some environmental mm-hmm.
Issues. For example, the value of perhaps clearer environmental labeling mm-hmm. on goods. We've also, within the CMA, set up a sustainability task force. Mm-hmm. And that's the idea of that is to draw together everything we're doing across the board on sustainability to make sure we have a joined up, focused approach.
Mm-hmm. I'm glad that you mentioned that, from the competition law perspective. But I think greenwash, false labels, that's more of like a consumer protection angle as well. So how does those two, I guess in here in the US, we sort of see them as two separate, very adjacent areas of law. How do they, I guess enforcement-wise, how do they go hand in hand within CMA?
Well, we are both a competition authority and a consumer authority.
Right.
At the moment, our powers in relation to consumer law mm-hmm. are less strong than in relation to competition law, and we are hoping for some legislative reform mm-hmm. on that. But in the meantime, it really goes back to what I was saying earlier about targeting. Once you decide mm-hmm. that sustainability is important, mm-hmm. then you don't say, oh, well, it's a competition issue, it's a consumer issue, it's something else. You say, let's look across the instruments we've got and decide how we can most effectively address the issue.
I very much agree that. So you must have seen practitioners coming your way, daily basis, and you've seen many of them. Do you have any good tips for them to be more effective and successful, to be in front of you and in front of your agency?
Good lawyering mm-hmm. is really important for us as an agency. Mm-hmm. If we have effective advocacy, mm-hmm. that helps us. It helps
whatever the outcome, it helps make our decisions better. So we welcome kind of lawyers perform it. We welcome lawyers who perform that role and perform it effectively. The tip, I wouldn't call these tips, but some observations that I would make is that it's, of course, important that lawyers advocate for their clients strongly and in the right way. Focus on the relevant, not on the irrelevant. The best lawyers, in my experience, kind of understand what it is we as an authority are looking at and are concerned about and seek to address those concerns. They don't kind of try and throw in every conceivable argument, however weak and hopeless it might be. So argue well, focus on the questions on issue, build trust, and that's the way to get effective representation.
That's all very sound advice. We also want to learn a little more about you as a person. Do you have any interesting hobbies or accomplishments that outside of competition law? Obviously, that's one of the things that you're interested in. But outside of competition law, what are you interested in?
Well, let me tell you one other thing that I do in a public role outside of competition law, which is, as you mentioned earlier, I'm the deputy chair of the Office for Students, which is the regulator for higher education in England. And one of my key passions on that is to ensure that we can widen access and inclusivity into higher education for people from backgrounds who traditionally didn't go into higher education. So my objective and our objective as an agency there is to ensure that every person who is capable of benefiting from higher education gets a fair chance to get that choice, and that's something I've always felt passionate about that, and it's great to have the opportunity to be involved in an agency where we can start to put that into practice. Yeah,
as a follow-up, if I may, how does the two core passions of you just sort of come together, and do they somehow affect each other? Do you perhaps if there is a competition law cases that, also involves higher education, I just wonder how that would all unpack in front of you.
Well, I think that I think they kind of unpack in a slightly different way. I think it's very important that competition law, which is concerned with consumer welfare, recognizes that consumers, of course, come from different backgrounds and have different contexts. There is not, although economists sometimes might like to think this, in fact, there is not a one-size-fits-all type of consumer. And just as in higher education, it is important to recognize the individual characteristics and circumstances of different students, because that's the way you get the best outcomes. So it is important in competition law when one is applying the instruments, and of course we do that on the basis of the law and economics, we understand that consumers have different needs and different requirements. When we're prioritizing cases, when we're looking at remedies, it's always important to have that in mind.
Yeah, very sensible. Thank you so much. It's our pleasure to have you.
Thank you.
Thank you for listening to this week's episode of our Curious Amalgam, a competition, consumer protection, data protection, and privacy law podcast. It is produced and shared around the globe by ABA's Antitrust Law Section. The opinions expressed by the participants in this podcast are their own and do not necessarily represent their employer or other organizations. If you like what you heard or would like to become a member of the American Bar Association, please check out what the Antitrust section has to offer at ambar.org/antitrust. You can learn more about our podcast at ourcuriousamalgam.com. If you have comments, suggestions, or podcast ideas, please reach out to us at podcast@ourcuriousamalgam.com. Until next time, thank you for listening.